All right, we've just ticked over right on 12. Welcome to those who are online, and thanks for joining us. I'm Rebecca Pezzutti, the Legal Practice Director at IRiQ Law, and I'm delighted to welcome all of those joining us online as we ride off into the sunset of 2025 and take a quick look in the rearview mirror at the year that was in employment and industrial relations. Let me start by acknowledging and paying respects to the traditional owners of the lands on which we meet. For those of us here in Brisbane, Minchinton, it's the Yagara and Turrbal people. Let me introduce my wonderful team who will be taking us through today's presentation. Joanna Minchinton is an IR superstar, known to many of you. She leads our legal and consulting practice. And we have Troy Axelsson and Riaan Hanekom, not to be confused with Rihanna, who are part of our legal team, and they support the great work that we do for our clients. So just a little bit of housekeeping. We are recording today's session, but all participants are muted and off camera. We will supply the slides and after the event, and the recording will be available on our website in due course. So you can revisit the presentation and information at any time you need to. We wouldn't be lawyers if we didn't give a legal disclaimer that this is general information and not legal advice. But if you do have any specific questions or concerns, we are here to help. So please reach out to our team via any one of our communication channels. You'll see today that we have a fairly ambitious agenda for the time allocated of an hour to walk through these key topics. So we will get started and we'll do that by looking at a rapid fire wrap of 2025. So in chronological order, I suppose, in terms of some of the amendments and legislative changes that came through this year, from the 4th of April 2025, there were new workplace gender equality agency reporting targets for large employers, so those with 500 employees or more. And that's a requirement to report against new gender equality indicators. And employers will nominate 3 of those indicators that they will report on, with the first round of reporting due in April and May 2026. And the gender equality indicators include things like the gender composition of the organisation and its governing bodies, equal remuneration, not surprisingly, the adoption of flexible working arrangements and support for parents and carers, the prevention of sexual harassment and sex-based discrimination. From the 1st of July 2025, superannuation increased to 12%. That's obviously no surprise, it's been on the cards for some time. Paid parental leave was increased to 24 weeks. That's the government funded paid parental leave. It's paid in line with national minimum wage and it can be shared between both parents. So there's a great deal more flexibility that's been added to the paid parental leave scheme. Superannuation will be payable by the government on paid parental leave under its scheme. We saw the annual wage review in July deliver a 3.5 increase to minimum wage rates. From the 26th of August 2025, the right to disconnect and employee choice pathway came into effect for small business employers. Interestingly, there's been some discussion from the President of the Fair Work Commission about the right to disconnect, coming up to the first anniversary of its implementation in large or all but small businesses. And the President of the Fair Work Commission described it as a fizzer in the sense that it has not generated a lot of disputes in the Fair Work Commission. However, an alternative view that was offered by Professor Andrew Stewart is that the absence of disputes around the right to disconnect is probably a good indication that these laws have helped employers and employees to rethink and cooperatively negotiate the boundaries between work and private life, and in particular, when employers should be getting in touch with employees after hours. So the lack of disputes might actually be an indication that that's all panning out okay. The employee choice casual pathway has been around obviously for all but small business employers for some time, and in August 2025 came into effect for small businesses. The most recent change has been the 7 November introduction of what's known as Baby Priya's Law, and it's essentially a new provision of the Fair Work Act that prohibits an employer who has a paid parental leave scheme and has granted or approved a paid parental leave application for an employee from cancelling that leave or denying that leave if the child is stillborn or dies soon after birth. That's not a new entitlement across the board, though, in the sense that it's always subject to the employer having a paid parental leave scheme and an approved application under that scheme. And the exceptions to that scheme include, for example, that it's subject to the terms and conditions of any employer scheme. So if the employer scheme expressly excludes entitlements in the event of a stillbirth, then that will remain applicable. Or if the employer paid parental leave scheme has some other entitlements that arise in the event of stillbirth. So that's a wrap of some of the changes in 2025 that we won't get to in any detail. And I'll hand over now to Joanna to walk us through some of these other interesting issues in a bit more detail.
Hello and welcome. I'll jump straight in and start talking about flexible working arrangements. So we've seen some developments in 2025 as to what's happening from this perspective arising from the amendments to the Fair Work Act. You'd be aware of those that occurred on the 6th of June 2023, where the Fair Work Commission has the ability to deal with disputes related to a flexible working request that's made under the Fair Work Act at Section 65. So to recap, eligible employees can make a request for a flexible working arrangement in certain circumstances, including where the employee is pregnant, the employee is a parent or has responsibility for the care of a child who is school age or younger, the employee is a carer, the employee has a disability, the employee is 55 years or older, the employee is experiencing family and domestic violence, or the employee provides care or support to a member of their immediate family or their household who requires that care or support because that member of the family or household is experiencing family and domestic violence. So as a result of the amendments that came through in June 2023, we've actually seen quite a bit of case law from employees who have had their flexible working request refused. They are obviously not happy with the refusal, and so they have gone to the Commission seeking the Commission's intervention, and in some cases seeking the Commission to arbitrate it and actually issue the flexible working request that they have sought for. So there are several decisions that provide some really good guidance as to how the Commission is going to deal with a particular claim, what they see as being the key issues from both the employer and the employee's perspective. So to reinforce that, I wanted to talk about one particular case. It's a recent case and you may have heard of it, Chandler and Westpac. Now, the circumstances in this are that Miss Chandler worked for Westpac and is still working for Westpac and has done so since 2002. She's worked in a number of different roles and from 2017 has worked remotely. Her team is based in a couple of locations in New South Wales and in Tasmania. So there were some workplace policies in place that allowed hybrid work. As a result of a change to the policy, she made a request on the basis of her caring and family responsibilities for her two school-aged children who were both 6 years old at the time. When she made the request, Westpac refused it, but they refused it 2 months after the request. There were then a number of discussions to see whether an agreement could be reached in terms of an alternative flexible working request. However, Westpac held the position that Chandler needed to return to the workplace to be in the corporate office in Sydney 2 days per week. Now, Chandler was unhappy with this decision and lodged a dispute for the Fair Work Commission to deal with it. Now, in terms of the outcome, you can see it on your screen. The long story short is that the Deputy President considered a number of factors and granted the flexible working request as Ms. Chandler had requested it. So essentially, the order provides that she can continue to work remotely on a permanent basis. And this is an order that has standing for as long as Ms. Chandler continues working there. So from a lessons perspective, there's a few things to consider. What we've got is the procedural aspect. So the Fair Work Act outlines the procedural requirements. As I mentioned, Westpac responded 2 months later. There is a 21-day time frame that didn't follow. And this can be a challenge for an employer who's defending their decision why they did not grant the request. So they need to be ensuring that they follow that request. The other aspect of it that wasn't a factor in this decision, but was in another decision of Jordan, Clerk and BSR Australia, is that the employee has to make sure they make a proper request. Not a request for a discussion about it, but for a request for a change. And in that situation, Clerk made a request via a Teams message for a discussion. The Commission found that it wasn't actually a formal request. The employer needs to be clear on the employee needs to be clear on the reasons for the request and the basis for it. So again, in the situation of Clerk and in another case, Gregory and Maxia, it wasn't clear to the Commission what the request was and how it related to a flexible working request. So there wasn't a sufficient connection. And in those situations, those two cases, the Commission did not accept the request. There also needs to be reasonable business grounds. So reasonable business grounds are not simply about preference. So that was the case in Chandler. We also have another case of Gregory and Maxa, who also confirmed that the reasonable business grounds have to be very clear to be able to justify through clear examples. So what we're seeing from the Commission is definitely an increase in dispute notifications from aggrieved employees, but we're seeing some really good through our case law, indications of how the Commission are actually going to be looking at their assessment. So that's working from home, flexible working requests. I'd now like to hand over to my colleague Troy, who's going to continue the theme of working from home with an overview of the Clerk's Award. Troy, over to you.
Thanks very much, Joanna. My name's Troy Axelsson and I'm a solicitor at IRiQ Law. And as Joe mentioned, I'm here to outline the main changes to work from home and in particular how the Fair Work Commission is trying to incorporate it into our modern awards. So back in 2023-24, a modern awards review was conducted by the Commission and a whole host of awards are being considered for review. But the working from home term has been selected to be updated and amended in the Clerk's Private Sector Award of 2020. And that's thanks to the legacy of COVID working from home arrangements and how there's been a few informal agreements between employers and employees in this respect. And then the whole objective of this review is just to formalise working arrangements and to remove existing award impediments. So obviously, there's an appetite amongst the modern Australian worker to work from home and certainly hybrid and remote work arrangements aren't going away. They are definitely here to stay. So 40% of clerical workers are currently working from home. So that's why the Clerk's Private Sector Award was chosen initially for the inclusion of the working from home term. So who's involved with this, with the review and making submissions? Well, various stakeholders, including unions and employer groups. Those groups are advocating for a right or a right to request the work from home arrangement, and others are wanting a more facilitative clause where there's an agreement between employers and employees. It's timely for all employers to consider what's ahead. So it's prudent to say that early preparation for employers equals less headache. So it's been suggested that employers do review and formalise current flexible working arrangements, and to think about how they're going to manage the work from home policy in terms of performance management of employees, how you will conduct Teams meetings and workloads to be completed and so forth under the remote working model. So work health and safety doesn't stop at the office door. There's been suggestions that a self-assessment checklist for home offices can show that that the employer is taking reasonable steps to protect staff. And there's also the consideration of how employers may need to contribute to the ergonomic setting of the home working environment, as far as contributing to equipment, furniture, and internet. While nothing is set in stone yet, it's worth just thinking about your stance moving forward, and think about what's fair and sustainable for your business, so that you're ready when the changes do come along. And that's all I have on the Clerk's Ward and working from home. If you have any questions about that, please reach out to us at the end. But in the meantime, I'll hand over to Rebecca.
Moving on, thanks, Troy, from the work from home topic and change of pace in enterprise bargaining. So I guess just to deal with some issues and trends, particularly as we see the reforms that came into effect in 2022 around secure jobs, better pay, really coming to fruition. So we're currently seeing these numbers reported by the Fair Work Commission, which reflect the fruits of the December 2022 Secure Jobs, Better Pay reforms in a couple of ways, principally by the expansion of multi-employer bargaining, which has supercharged bargaining for single employer agreements, but also we've since seen the creation and very large-scale adoption in the case of early childhood education of the multi-employer agreements in particular industries. So in terms of the numbers here, we've only got numbers to March 2025, but what they do show is that there are firstly an increase in the number of in-term agreements, and that was driven largely by activity in response to the introduction of changes to multi-employer agreements, whereby the strategy adopted by a lot of employers at that time in around June 2023 was to either renew an expired agreement or ensure that they had commenced bargaining for an agreement to isolate themselves from the prospect of being drawn into multi-employer agreement, because at that time there was just such a great deal of unknown around how that would look. And so on the figures you see from March 2024 and 25, a significant jump from the prior years in the number of agreements and the number of employees covered by agreements. in circumstances where an in-term agreement is the best defence against being named in a single interest employer authorisation or being roped into a multi. And then the other way that we've seen bargaining really supercharged is by increasing the number of agreements, in the sense that employers who might not previously have had an agreement have initiated bargaining in an effort to take control of the process on their terms and insulate themselves from the risk, which particularly at the introduction of these reforms was very much an unknown as to how it would play out. What we do know, what we knew then and what we're now seeing, is that those reforms were designed to improve rates of bargaining, which had become stagnant. And in that sense, those reforms are having their intended effect. Like I said, by on the figures alone, more employees covered by more agreements. The most recent figures published by the Department of Employment and Workplace Relations in June 2025 has put the total employees covered by EAs at 2.8 million, which is up significantly from the last data set there in March 2025. March 2025, and that's the highest figure on record for the number of employees covered by an EA. And in terms of the data around annual wage increases via bargaining in the private sector, this was at 4.3% to the June quarter, with union-based agreements achieving higher increases than non-union agreements of around 0.4%. So when you even compare that to the Fair Work Commission annual wage review of 3.5, you can see how bargaining is being used as an effective tool by unions to lift rates of pay. So in terms of what we've seen in trends, although particularly in multi-employer bargaining, although it has always been a feature of the Fair Work Act, the Secure Jobs Better Pay reforms broadened access to multi-employer bargaining, with increased scope for employees to be forced to bargain, employers to be forced to bargain for a multi-employer agreement. A good example of this is the case of the McDonald's franchises in South Australia, who were drawn into supported bargaining in circumstances where the SDA who led that application, were pretty frank about the fact that they actually didn't have the membership density in those McDonald's stores to get, for example, a majority support determination. But by using the supported bargaining stream, they were able to force those franchises into multi-employer bargaining. I'll come back to that particular case because it's still on foot with the decision under appeal. But broadly, the multi-employer bargaining reforms have broadened the requirement for employers to have an identifiable and common interest, or that's essentially the threshold issue for being named as an employer on a single interest employer authorisation. How the Fair Work Commission applies this definition has so far imposed a very low bar in terms of what's required to demonstrate common interest. Now, in the single interest employer authorisation stream, there is a presumption of common interest where the employer employs more than 50 people. So in terms of what we've seen, there are some mixed results around employer responses to union applications. Some employers have welcomed the changes as a means to level the playing field by removing competition on wages or obtaining access to government funding to support wage lifts. So that's been some of the more positive outcomes in this space, and I'll come to the discussion about early childhood education. And those who are vehemently opposed, not surprisingly, the mining industry. There's been a high level of disputation around attempts by unions in that space to draw mining companies into multi-employer bargaining, and I'll touch on those as well. So starting with supported bargaining, which affects low wage industries. McDonald's in South Australia, 18 franchises, which I understand is all of the McDonald's franchises in South Australia, were forced to bargain with the SDA in circumstances where they would not have otherwise had sufficient coverage to force a majority support to termination. So the SDA strategy, as far as we understand it, is to rope in other states. So this is potentially a model for what you can expect to see in the fast food industry, but potentially more broadly in other industries, is for a union to isolate a group of employers in one location, potentially the softer targets, and then rope in more broadly other employees in other locations where there's still a position that there's a common interest. So there might be more activity next year in relation to McDonald's in other states, and no doubt we'll hear about that. And the price of a Big Mac may well go up. So common interest in that case was established because paying conditions in the fast food industry are generally at or near minimums, and McDonald's licensees have clearly, the Fair Work Commission accepted, had clearly identifiable common interests. And this was principally around things like the standard form of franchise agreements that they were operating under, the McDonald's system, which creates uniformity in operations and standardised roles, and in circumstances where bargaining is otherwise very low in McDonald's franchises, in circumstances where McDonald's employs almost half of all employees in the fast food industry, but has very low bargaining rates. Now, this decision is being appealed, and it's currently with the federal court. So we will expect to hear more about that in 2026. In the single interest employer authorisation stream, we had the professional union in the mining industry seek a single interest employer authorisation involving Peabody, Whitehaven, Delta Coal and another mining company, and they wanted to have their professional employees, who are the deputies, under managers, shift engineers and control room operators, across several underground mine sites in New South Wales, covered by a multi-agreement. Now, all of these mines that were the subject of the application operate in different regions, and they all use different mining methods. So the application was opposed by the employers on the grounds that there was not a sufficient common interest. The Fair Work Commission held that there was a common interest because they're mining for the same commodity, and made orders. Now, that was opposed under appeal, and as it transpired, Peabody closed one of its mines, the one that was the subject of the agreements, the order. So no bargaining has actually taken place over this issue, but there has been a lot of litigation, and the decisions are well worth reading when it comes to the Fair Work Commission's consideration of the competing arguments, which I've well and truly oversimplified. So I would recommend that if you're interested in that, or you think there's a prospect of your organisation being involved in these sorts of cases, then it's well worth being across. The appeal is still on foot, though, so the court will still determine the appeal and deal with the concerns that were raised by the employers in the case around the scope and limits of common interest in multi-employer bargaining authorisations. So that's still very much under the spotlight. And so we can expect the federal court to deal with both of those things in 2026, and it'll be really quite interesting to see if the federal court takes a different view to the commission around some of those things. And in the supported bargaining space, I alluded to the Early Childhood Education Centre multi-employer agreement. This is by far the largest multi-employer agreement. It was effectively prosecuted by consent between the parties. So in December 2024, the application was commenced by agreement between the United Workers Union, the Australian Education Union and the IRiQ, and 60 early childhood education centre employers. It has since grown to cover 289 employers and approximately 45,000 employees who opted in to be covered by the agreement. And so we expect this to become something of a model for the future applications in the care sector, at the very least. So there are two schools of thought, like I said, a range of responses from employees. Some might say, well, we want to minimise the risk of being forced into a multi-employer agreement or multi-employer bargaining, in which case the approach to adopt is to have an interim enterprise agreement at all times. But other employers may take the view that they want to explore whether multi-employer bargaining is actually going to be a good fit for them in their business and industry, and is it worth taking control if multi-employer bargaining is likely by initiating that, setting the terms with a view to achieving a level playing field. So a few things to think about there in terms of what we've seen, but I will hand over to Joanna to talk through some of her insights as a bargaining representative.
Thanks, Rebecca. So it's really interesting when we're talking about bargaining because, as Rebecca's alluded to, there have been quite a number of changes that have come through as a result of the current government in its current term and its previous term to the process. In my role at IRiQ, I often act as an employer's bargaining rep, which means I'm formally appointed to be a representative for the employer in this. And what I thought I'd do is share some insights that I've seen this year as I've been assisting various clients with their agreements. The first thing is the operation after the nominal expiry date. We've seen a couple of circumstances where an agreement has passed its nominal expiry date. It still continues to operate. It still is a legally binding document. However, what it does also mean is that if you have a union interest or a union who has been a party to the agreement, once the nominal expiry date has passed, they have the ability to request you to bargain for a replacement agreement. What that means is that you are then required to enter into that bargaining process. You can't remove yourself from it. You find yourself bargaining and going through the various motions. So that's something, if you do have an agreement that has passed its nominal expiry date, just be aware of that as a potential avenue for union involvement. Obviously, I'm providing it in very short form, and we can discuss at a later stage, or if anyone's got any questions, pop it in the chat function and we can talk about it at the end of the session. Strategy is very important when it comes to negotiating your agreement in terms of what you want, why the agreement is important to you. The circumstances have probably changed quite a lot. If you're looking to renegotiate an agreement at the moment, your current agreement might have been a 2001 to 2005 agreement. Things have changed quite a lot, and you'll find that terms of awards, terms of the Fair Work Act have changed. If you just simply want to update your agreement for compliance, that's one thing versus actually looking to introduce changes or pare back arrangements in the existing agreement. That strategy would drive you through the entire process, whether or not it's negotiating with employees, negotiating with unions, or just simply developing it for discussion with your employees in the absence of bargaining representatives. The third point you'll see is good faith bargaining. Now, this has been raised a a number of times in terms of the way people interact with each other during the bargaining process. There is a protocol that I generally will introduce from the first bargaining meeting and continue the reinforcement and the express commitment from the parties at the beginning of each meeting. Now, good faith bargaining is, as it sounds, it's about bargaining, and it's about bargaining in a way that shows that consideration, that responsiveness, that allows parties to be heard. The important thing about good faith bargaining is that it doesn't require, for example, if you have a union saying to you, we want this sort of increase, good faith bargaining does not require you to agree to request if it's not actually viable for the business. So please don't get caught up in the concept of good faith bargaining and feeling that you have to agree to everything that's being put forward. Same on the other side as well. And we do recognise it's a reality for a lot of businesses and a lot of unions in the negotiation. The end agreement might not be 100% what either party wants, but good faith bargaining is about the responsiveness, showing consideration to claims that have been made, recognising bargaining representatives at the table. So a couple of things specifically for the agreement that I wanted to mention as well. Communication during the access period. So you've gone through the bargaining process. The access period has commenced, ready for a vote in 7 days timeframe. Communication with your employees is really important. One of the things that we take a lot of time to do is prepare comprehensive information about the proposed agreement. Now, the Fair Work Commission has a role when it comes to approving an agreement in line with the Statement of Principles that was introduced a couple of years ago. And one of the key elements that we see coming up, or that I've seen coming up, is the genuine agreement. So has an employee, when they've cast their vote to either approve or not an agreement, genuinely understood what the agreement was about, that they have an interest in the agreement and therefore have cast their vote with that understanding and with that genuine agreement to it. So access period material has grown in terms of the type of information that you put across to help to ensure that the Fair Work Commission is satisfied that employees have genuinely agreed to it. So we've seen with a couple of agreements that we've done recently that communication through toolbox discussions, even information sessions, read through the awards with the employees is a great way of confirming that they're aware of it. The other aspect for genuine agreement is ensuring that your employees do actually understand it. For example, some employees in a recent agreement we did, it was understood by the employer that they were dyslexic. There are actual fonts for your typewritten notes that are more helpful for people with dyslexia to read. So consider those types of strategies to ensure that communication is as effective and efficient as possible. Next on the list is the NES Award Precedence Clause. This is something that the Commission will always look for when it comes to the approval stage. So while we know that the NES in the Fair Work Act must apply to everyone at all points in time and an agreement cannot override it, a clause that confirms that the NES will always take precedence is a clause that will need to be included in your agreement. Likewise, if you have an agreement that is simply looking to change a few provisions of the award and incorporate the rest, you will need to make sure there is a precedence clause as well. So that brings me on to the third point about the agreement, reproducing clauses versus incorporation. This is part of your drafting and part of your strategy as well. How do you want your agreement to operate? And generally, you'll either have an agreement that replaces the award in its entirety, which will make for a very long agreement because it needs to cover everything that is in the award from the better off overall perspective, or you will incorporate clauses into the award and work in conjunction with the award. So the correct wording to ensure that there's no ambiguity there is important as well. Now, something that I added in as an extra point, not as a bargaining representative, but in response to a number of queries that we've had from employers who have an existing agreement, and they've asked, can you terminate the agreement if you want to go back to the award, you don't want to negotiate a new agreement? The short answer is yes. But the longer answer is that there's a strategy and there's communication and there's a process behind it. If you have an enterprise agreement with a union, it's about to reach its nominal expiry date, or it has in fact passed its nominal expiry date. If you seek to terminate the agreement, you lodge an application. Parties to the agreement will be asked for their view. So a union, you can probably feel fairly confident that the union will not want the agreement terminated. What they may do, as I mentioned earlier, when it's past its nominal expiry date, they may then seek to request to bargain. Termination during the nominal expiry date is a fairly complex process, and employees, all parties to the agreement, have to agree for it to be terminated before an application can be made. So if you are thinking, what am I going to do with my agreement? There are a few things to consider there, and I mention this because it is a lengthy process to proceed, and that will form part of your strategy in terms of, do we renegotiate or do we simply look to go to the award next as your next step? So a few insights, as you can see on the slide, to give you a sense of what's happening on the ground with employers in the bargaining space. So I'd now like to hand over to my colleague for our next topic, which is on wage compliance. So over to you again, Troy.
Thanks, Jo. And just being mindful of the time we have left, I'll go through wage compliance as quickly as I can, but hitting all the high points. So the criminalisation of intentional wage underpayment is one of the pivotal reforms under the closing loopholes, which was introduced on the 1st of January this year. It reflects the Commonwealth's commitment to addressing wage theft as a serious criminal offence. So under section 327A of the Act, an employer commits an offence if it engages in intentional conduct which results in wage theft. For whatever reason, the employer fails to pay a required amount in full on or before the payment is due. So we're talking serious and significant underpayments here. Generally speaking, honest mistakes and oversights like payroll system glitches and coding errors won't necessarily be considered as one of those wage theft underpayments. However, while there is a criminal element to wage theft and compliance, there are still civil liabilities imposed, and compliance notices can be issued in respect of wage underpayment. So traditionally, seasonal workforces in agriculture, construction and horticulture have been the main offenders of wage underpayments in respect of paying below the minimum wage, not issuing proper pay slips, and in some cases not paying superannuation entitlements. So the whole objective of one of the objectives of this reform is to target previously exploited employees and to basically call those offending employers out over those types of issues. So with the new law in effect, employers who deliberately withhold employee entitlements are exposing themselves to the risk of criminal prosecution. However, there are safe harbour provisions to cater for the employer once they become aware or have knowledge that they might have caused a serious or significant underpayment. So for small businesses, the Fair Work Ombudsman has asked them to adhere to a voluntary small business wage compliance code, and for larger businesses, that looks like a cooperation agreement. So basically, while the agreement is in force, the Ombudsman can't refer the conduct of underpaying to refer it for criminal prosecution. So the penalties imposed are severe. For companies found of wage theft, it can be up to $8 million or 3 times the underpayment amount. And business owners, directors and managers can now be personally held accountable, and they can be fined into the region of $1 to $1.5 million or 3 times the underpayment amount. Also, it's important to remember it's not just the business managers and directors who are at risk here. It can be HR managers or anyone else that is complicit in the knowledge or awareness that a significant or serious wage underpayment is occurring or may be occurring. And the only other thing with this reform is that it doesn't apply retrospectively, so it only applies to wage underpayment from the 1st of January of this year onwards and moving forward. So that is all for me in regards to wage underpayment, and I'll hand back to Joanna now. Thanks, Joanna.
In terms of what we're now going to talk about, this is not an example of wage theft. We haven't actually seen any case law yet that has been or cases that have started under the new wage theft provisions. But this case, you've all heard about it, the Coles and Woolies, the supermarkets case. And I will mention that given the time that we've got, as Rebecca mentioned at the outset, it's an ambitious agenda. I will only be going through this at a very brief level, but what I'd like to refer you to is one of our vlogs. We do them every month, IRiQ Talking IR, and on the 10th of November we did dissect, we looked at, we analysed this particular case. So that's available on the IRiQ website for anyone who's interested in having a listen to that. It's slightly longer than our normal vlogs, but there's a lot to talk about with this case. So I think the main thing about this case is that there are quite a lot of implications for employers. So the first thing to be aware of is that in this particular case, the employees were covered by an award, the General Retail Industry Award, and there were salaried provisions that were put in place for team leaders and managers. And those salaried provisions also included a set-off clause that actually allowed the extra payments that fell due under the award to be paid over a longer period. In this decision, and I should also say, we're still waiting to hear whether it's going to be appealed or not, but until we hear that, it does set an expectation, which is that you can only offset extra entitlements through your salary for the pay period that is detailed in the award that applies. So in this situation, the award had more frequent pay periods. Each of those pay periods, there should have been, according to the federal court, a reconciliation to ensure that all employees receive what they should have received at the time that fell due to the employee. So Coles and Woolworths were found to be not compliant from that perspective as well. There were a couple of other things that came out of this case as well, which is the need to ensure that you've got some payroll systems in place that allow you to do those reconciliations for the pay period. Record keeping was found not to be sufficient. Record keeping is very important for an employer, even if someone is being paid an annual salary. You may be aware that if an employee were to pursue a claim of underpayment, the onus of proof is reversed. So an employer actually has to disprove the allegations that an employee makes of underpayment. So in this case, the supermarket's case, it was a significant hurdle for them to overcome because they had insufficient records that were required under the Fair Work regulations. So that was the key point that came out of this as well. The other thing is in terms of checking for overtime. Overtime under an award attracts a higher rate of pay. Implementing policies that confirm that overtime will not be paid unless it is authorised is one thing that I know a lot of employers do. But the key to enforcing this is to get your managers involved to make sure that they are checking the timesheets and they are correct. So that can help to avoid issues coming in down the track. So again, given the material that we're covering today, I'll leave my analysis there. But if it does raise questions for you about how your annualised salary works, how award coverage applies, because an award will always apply to an employee unless you pay them a guarantee of annual earnings, which is currently over $183,100 per annum. If you've got any questions about that, record keeping, payroll, auditing, remediation, please feel free to reach out after the webinar. So we're going to quickly move to our next discussion point on wage theft, and I'd like to hand over to my colleague, Riaan.
Thank you, Joanna. Yes, as you mentioned, continuing the topic of wage compliance, 2025 has really been an industrious year for the Fair Work Ombudsman as it relates to enforceable undertakings. Essentially, an enforceable undertaking is just a legally binding agreement that an employer or business will enter into with the Fair Work Ombudsman, typically where there's sort of instances of underpayment of employee entitlements. And it, as a mechanism, it represents quite a preferable alternative to litigation under the Fair Work Act. So briefly, just the components of an enforceable undertaking, and then I'll show some examples. But of course, you must correct the underpayment. I think that goes without saying. Superannuation and, importantly, interest on the outstanding amounts that the employee would have earned. The all-important contrition payment. And then finally, you subject yourself to continued compliance audits. All of these can represent quite a significant burden on employers and businesses. But perhaps the hidden cost also that one doesn't always think about, the damage to your reputation as an employer, if you're attempting to cement yourself as an employer of choice, the damage to your employee goodwill in having to sort of, come to the fore with all of these underpayments. And if you're concerned that it's one thing we do see is that it's not only small and medium enterprises that are getting wage compliance wrong. It's, as we can see here on the screen, it's quite significant organizations. It's large organizations, and especially universities. And as we can see, while the underpayments might be one thing, the contrition payments are still quite significant. So if you haven't been planning for an unexpected contrition payment, of course, no one plans to underpay, but that can impose quite a significant burden. And it really does reflect the importance of conducting regular payroll audits, as Joanna mentioned that just now, in the context of offsetting, in the context of ensuring that you're paying your employees correctly. With that being said, I think I might hand over to Rebecca at this point to take us further.
Thank you, Riaan. All right, so just on the downhill stretch, we'll skip over a couple of these slides to move through determination and redundancy. So very high level, there have been developments in the general protection space. An issue that we've seen arising in the Fair Work Commission is that general protections are very broadly being used as a substitute for unfair dismissal claims, rather than to prosecute what are genuine unlawful dismissal claims. That's the view expressed by the President of the Fair Work Commission, anecdotally premised on the notion that employees who don't meet the minimum employment period to qualify for unfair dismissal are more often than not under the advice of paid agents, prosecuting general protections claims as a means to get the employer into a negotiation, also known as a shakedown. What we are seeing, though, is that 80% of GP claims that don't settle at conciliation don't actually progress further. So I think that there is a lot to be said for employers being prepared to say there's no money on the table here in those truly unmeritorious sort of claims will dissuade this sort of behaviour. But the Fair Work Commission has also stepped in with a range of measures that have been designed to limit the ability of individuals to prosecute these claims in the Fair Work Commission, including the requirement for, so the forms have been changed. That's the first thing that's happened. If you've seen a general protections application recently, the ticker box aspect of the applications is gone, and applicants have to be able to articulate the grounds of their application. And if there's a late application, the Fair Work Commission now has a pre screening determination before it even hits the employer to determine on the papers whether there should be an extension of time. And limitations are being imposed around the use of lawyers and paid agents in straightforward general protections claims. Conferences are being sort of really truncated. If an employer turns up and says, look, we're not here to negotiate, then, and I have done that for some employers on instructions in appropriate circumstances, the conference gets terminated. So the Commission does not have time to waste on these things. And we're happy to say that so far that strategy has been effective in truly unmeritorious cases. Yeah, I just went through that slide. So that's just a summary of the changes the Fair Work Commission has imposed on process in an effort to manage the otherwise unsustainable workload arising from the huge increase in numbers in GP claim filings, alongside the massive increase to the Fair Work Commission's workload more broadly as a result of a range of the reforms to the Fair Work Commission, the Fair Work Act. On termination and redundancy, I think what's been of interest for some of our clients in the labour hire space that's worth discussing is the dismissal risk that's really coming through from more recent cases. So those in labour hire providing ordinarily labour that's employed on a casual basis into a host organisation on might be a short-term, long-term assignment. The line of thinking has always been that when the assignment is terminated by the host in some circumstances, or because the assignment comes to an end, the employee remains employed by the labour hire company and pending reassignment, essentially. Of course, what we see happen is host employers directing that the supplied labour, an individual, not be returned to site or not be returned to the project, and ordinarily that individual doesn't have an unfair dismissal remedy against the host because technically they're still employed by the labour hire company. So that's changing. What we're seeing is the Fair Work Commission in a range of cases being more prepared to actually find that the termination of the assignment at the direction of the host employer amounts to a dismissal. And so it's certainly introduced further dismissal risks in labour hire arrangements that historically haven't necessarily been a problem. And so what we're seeing, for example, in Kimstar and WorkPack, which is probably the most significant litigation because it was there's a number of judgments in the federal court in relation to both liability and penalties that were imposed. WorkPack supplied Kimstar to a mine. She was there for a significant amount of time, made some complaints about the way that she was being directed to work, and was then demobilised, told not to return. WorkPack maintained that wasn't a dismissal, but on inquiry, the Fair Work Commission said every time she was according to her contract, every time she went on assignment, there was a new employment relationship. The same thing happened in a number of other cases. What we've ultimately found from an assessment of the reasons in those cases is that much will turn on a number of factors. The terms of the employment contract are going to be highly relevant to determining the nature and continuity of the employment relationship, but it's not going to be determinative of the issue. What the Fair Work Commission is really looking at is what is the labour hire provider doing at the end of that assignment to confirm the ongoing employment. And more often than not, that needs to look like active attempts to redeploy and active engagement with that person about redeployment on other assignments. So circumstances where you might just quietly let someone fade off into the casual abyss just do not pass muster anymore. You have to be continuing to engage with them promptly, otherwise you might find that they'll establish there's been a dismissal. So if you're in that space, I do recommend having a look at some of those decisions and thinking a bit about your processes for offboarding or demobilising or whatever you want to call that around the ending of a host assignment. So just bearing in mind the time, we've got redundancy and contractors, worth a discussion. We'll continue with that. I'll hand over to you, Riaan, for a discussion about the case.
Yes, thank you, Rebecca. Certainly every High Court decision is important to lawyers, but this has really been one of the cases of 2025 and in no small part thanks to its practical application and the practical implications. Sort of just at a high level, we have an employee who was dismissed due to redundancy, but the employer retained contractors who were doing similar work. Now, the High Court held that it would have been reasonable to consider reducing reliance on contractors. And so if redeployment was reasonably possible, then the redundancy cannot be genuine. So this case does have quite a long history. But importantly, what it does do is it raises the bar for employers. Employers must make sure that you consider all available roles, even if you do have roles that are being done by contractors. Previously, there might have been the notion that we only look to vacancies to see if there's any vacancy that the employee could fill, but that just simply isn't good enough. So with that being said, I'll try and contain my excitement further, and I'll hand over to Joanna as we look to what's happening in 2026.
Thank you, Riaan. So 2026, wow, well, we've had a huge 2025. So what I'm going to do is look ahead to what we can expect next year and provide a bit of a rapid fire approach to that as well. The first one here is the junior rates case. You may not be aware of this case, but the SDA has applied to the Fair Work Commission. They want to vary the General Retail Industry Award, the Fast Food Industry Award, and the Pharmacy Industry Award to abolish junior rates once someone reaches 18 years of age. What that means is that if granted by the Fair Work Commission, we will see employees under that award, those three awards, being viewed as adults at 18 years of age, which means the adult rate will apply to them. The SDA has also sought for junior rates for under 18 to be increased as well, from 16, 17 years of age. I mentioned this because I think it's the case, and the submissions were still being heard as late as the 27th of November. So it is definitely something we'll see concluding in 2026. The implications for this is that we may see some movement from unions or even the Fair Work Commission itself to vary other awards to reflect the adult rate applying when you turn 18 years of age. So definitely one to watch. Our second point on the agenda on the slides in front of you, paid parental leave. So we have seen from the 1st of July this year an increase to 24 weeks. From the 1st of July next year, it will increase to 26 weeks. So something to be prepared for. Payday superannuation is our third 2026 matter, and you'd no doubt have heard a bit about this. In short, from the 1st of July 2026, employers will be required to pay their employees' superannuation contributions under the superannuation guarantee at the same time as paying salary and wages. So this is definitely something to be aware of and start preparing from a payroll perspective to be ready for. Positive duty, statutory review and introduction of civil penalties. The Australian Human Rights Commission released a report in June of this year. The report was called Speaking from Experience Report, where they made a number of recommendations that build on the positive duty agenda that was seen through changes in the Sex Discrimination Act. A couple of those recommendations, we might see the movement of those in 2026, which is a collaboration of information sharing across jurisdictions. So, for example, the Australian Human Rights Commission and WorkSafe would be sharing information about positive duty non-compliance. Leading on from that, there is a recommendation to introduce civil penalties for breaching positive duty obligations as well. So definitely something for employers to be aware of. There's been a lot happening in the positive duty space. If you're in Queensland, there's a new requirement that came in March this year to have a sexual harassment and gender-based harassment prevention plan. That all forms part of positive duty activities. So there may be some things in addition to policies, prevention plans and other activities that you'll want to be looking at in 2026 in light of these recommendations. Now, number 5 on the list, I'm talking about AI and increasing Fair Work dispute claims. So something that the Fair Work Commission has acknowledged is that increase, and Rebecca talked about the general protections disputes increasing over the last short while. Now, this AI has a number of implications. As employers, it can help us in our daily work and can help with undertaking research and preparing information. What we are seeing is that AI is being used by employees who have had their employment terminated, who are wanting to make an application. They ask ChatGPT or any other of those mechanisms to prepare an application for them using the correct Fair Work Commission forms, and those applications are being submitted. There is a general view that those applications are going through thanks to AI, when traditionally a former employee wouldn't take the time to fill out the form or wouldn't actually know where to start. So the increase in Fair Work Commission disputes, I expect we'll see more of that in 2026, and employers be mindful of this. Be mindful that you might find yourself subject to processes in those tribunals that you might not have expected to find yourself before. Our final 2026 item to be aware of are non-compete clauses. So there was a lot of discussion about this earlier in the year about removing non-compete clauses for employees who earn less than the high income threshold, which would prevent restraints and other such types of clauses in employment contracts. The consultation process is continuing. We had expected to see something happen early next year. Latest indications are, with the consultation continuing, this might be towards the end of 2026 consideration for employment contract, if not into early 2027. So a couple of things to look ahead for in the industrial relations and employment law space. So we might move forward to our next section, which is just to answer any questions that we have. So Rebecca, over to you. Do we have any questions?
Thanks, Joanna. We do. We've got a question from Elizabeth. Thanks for posting that. And it relates to work from home flexible working request. So it's a situation where an employee has been supported above and beyond the normal policy for working from home. And the employer in that case has been permitting them to work 3 days a week instead of the standard 2, which I take to mean the policy says you can have 2, but they've given them 3. And that's been happening for about 2 years. Recently, that employee requested to work from home to support family challenges 4 days a week and 1 in the office. So the question is, does the fact that they've already gone over policy, over and above policy, present an issue around saying no to going further to accede to the most recent request? Great question, Elizabeth. I think our experience from, or our learnings from the Westpac and Chandler case are very clearly around policy, is that policy is not going to be highly relevant to determination of the issue. In fact, I might even go so far as to say it's probably irrelevant. I say that because in Westpac and Chandler, Westpac said, look, we've got a new policy and our new policy says everyone has to work from the office and we're just applying our new policy. And that was completely disregarded as a reasonable business ground. And that really takes you to the real issue, which is under the Fair Work Act, the only basis on which an employer can refuse a request for flexible working arrangements is on reasonable business grounds. Questions of policy don't feed into that. Very broad statements about not wanting to treat, not wanting to open the floodgates or treat, give people special treatment or other things won't come into play. What you really need to be able to point to is what are the business implications, operational, financial, for this proposed change. So we certainly be happy to talk that through with you more, but on the question of what impact does policy have on things, I would say very little. I would also probably indicate that an existing arrangement, as was the case in Westpac and Chandler, if it's working well, I think would be treated by the Fair Work Commission as indicative of the fact that the reasonable business grounds might not necessarily have any foundation. For example, if the business grounds are, look, it'll be unproductive, if the evidence is, well, the employee's been doing this productively for 2 years, the Fair Work Commission will be less prepared to accept there's a productivity risk. So these things become very fact and context dependent. In Chandler and Westpac, she was a very high performing employee. And I think in our vlog, I sort of raised the question, this wasn't, why would you run this litigation? This was not the battle to fight. You were always going to lose because you had an employee who was actually performing well and there was no apparent evidence about the impact of the request on that. So there are a couple of things to keep in mind, but we're happy to take it offline. Liz, if you want to give us a buzz and we can talk about that a bit more. It's something that we expect to see more of in terms of the request for flexible working arrangements, partly too because of the type of attention that these cases get. And, it doesn't really take much, unfortunately, for the media to get a really great headline from some of these stories, and people don't read beyond that. But a full-time work from home order certainly did make great headlines. There's more to it, but it certainly raises expectations in individuals' minds about what the landscape looks like in the future. Okay, Robin's logged off. Thanks for a session. No informative session, no worries. That's what we're here for. No other questions as far as I can tell. Excellent. Okay, so what's next? Well, how to stay in touch with us more than anything. We'll have a 2026 webinar program released shortly. If you want to get that direct to your inbox, just subscribe to our newsletter. In the presentation slides, there is a link via QR code to the website where you can sign up. So check that out. Otherwise, thanks again for joining us. We've enjoyed presenting, hoping you've got some value out of that, and we'll stay in touch. Thanks, team.